Hi, I'm Alan Beaver. Welcome to this episode of Understanding Tort Law, the Law of Private Nuisance. This episode is the third part of our discussion of remedies and related issues. And what we're going to do in this episode is we're going to reflect on the cases that we've examined in the first two parts of what has now become a rather extended episode. So we're going to discuss Sturgis and Bridgman, Miller and Jackson, Kenaway and Thompson, and Coventry and Lawrence. And I'm going to give you my views about these cases and about issues that surround them. In particular, we're going to think about the rule, the traditional rule, that who got there first doesn't matter, and we're going to think about what a remedy should be, what the ordinary remedy should be in cases of nuisance. Okay, so let's begin with who got there first. No. What's the justification for the traditional rule that who got there first doesn't matter? Okay, now the first thing to say here is that this idea that who got there first doesn't matter clashes with an intuition that many of us, perhaps all of us, have, that we can summarize by saying first come, first served. Okay, so we have this idea that, first come, first served, and this clashes with this idea that who got there first doesn't matter. Now, the one thing that needs to be said in this context is that the law does reflect the principle or the intuition that first come, first served. In particular, the law of property reflects this intuition. So just to take some examples, say I'm out fishing and I catch a fish and I reel it in and I actually haul it on board and capture the fish, right? Then the fish becomes mine. Why does it become mine? Well, in part because nobody else owned it and I captured it first, right? So there, first come, first served. I captured the fish first, it's mine. Similarly with some other kind of wild animal, say I'm a fox, or there's a famous New York Court of Appeal case called Pearson and Post that's like this. I capture a fox, right, before anybody else has captured it. The fox is mine. Why? Because I captured it first. First come, first served. And in principle, although in practice things are much more complicated, but in principle the same idea can apply to land. So if I get to some area of land first, this is not going to happen these days, of course, but if I get to some land first that nobody else has ever occupied, it's completely unowned, and I mark it out and I make it mine, I indicate that I want to exclude other people from it and so on. In principle, though, as I say, it's in practice it's more complicated, but in principle that land could become mine too. First come, first served. Okay, so this intuition that we have, first come, first served, is reflected in the law. But the key thing to notice about the cases that we've been looking at is that in these cases we are not dealing with things that are unowned. Right? It's land in these cases. We're not dealing with unowned land. We're dealing with land that is owned. So, for example, I can't come round to your house and go fishing in your fish pond and catch a fish. And when the fish comes up, say, hey, that's my fish now. Right? First come, first served, because the fish was already yours. Okay, so we're dealing with objects that are owned, not objects that aren't owned. And I submit that the principle, first come, first served, can't operate when we're dealing with things that are owned. Right, when we're dealing with things that are unowned, then the principle, first come, first served, can operate. But here we're not dealing with things that are unowned, we're dealing with things that are owned. The defendant owns the defendant's land, and of course the plaintiff owns the plaintiff's land. And because of this, because there's a conflict between the owners of the property, we can't settle this by saying who got there first matters. Okay, and think about this in a concrete context. Let's say that I live in a house that's very close to one of my neighbours. And those neighbours who live in the house that's close to me, they do shift work. So they're always out in the evenings working. Now, every night of the week, I play really loud music, but it doesn't bother them because they're not there, they're at work. And let's say that I've been doing this for a long time. Let's say I've been doing this for 10 years. Let's make it short of the prescription period for an easement so that we don't get tied up with the law of property here. But let's say I've been doing this for 10 years or 15 years or whatever, pick a number. I've been doing this for a really long time. And then let's say that my neighbours decide to move and another family move in and they don't do shift work. Can I say to them, oh, look, you guys, you're going to have to put up with my noise because I was here first. Now, I take it in that case, we don't think that because I was there first, I should be able to inflict my noise on my neighbours. We don't think first come, first served. Why? Because both properties are owned and they have their entitlements in their property that I can't take away from them simply because I was in the neighbouring property first. Of course, if I was in their property first, right, and I gained property rights in their property, then yes, in that circumstance I can dictate to them that they're going to have to put up with the noise. But I've never gained any rights to their property. How does the fact that I was in my property first mean that somehow I gain an entitlement to control their property? And this is, I think, the key to understanding the basis of the rule. Who got there first doesn't matter. If we didn't have this rule, if we allowed who got there first to matter, we would allow the defendant in these cases to gain control over the plaintiff's property when that property was never the property of the defendant. Right? We would allow the defendant to gain control over the plaintiff's property when that property was never the property of the defendant. So, in this case, I would be able to say to the plaintiffs, normally, yes, your property would entitle you to prevent me from making noise in the evenings, as we saw in cases like Halsey and Esso Petroleum. But I've taken that right away from you. I've removed that entitlement from you because I was here first making this noise. That's to give me some kind of legal control over your property, over my neighbour's property, right? Although I don't have any property in that property. Think about another case. Imagine that you might say, oh, well, that's a bit different than cases like Miller and Jackson and so on, because in that case, my neighbours move in and they don't know about the property. But imagine this circumstance. Imagine that my neighbour's property is being sold. So, the shift worker still owns the property, but he's selling the property. And they're selling by auction, and there are a whole lot of people at the house for an auction. Can I just stand up and yell over the fence, hey guys, by the way, I make really loud noise at night, so you guys are going to have to anyone who buys this property is going to have to put up with really loud noise, okay? Can I do that? No, I can't do that. Why? Because that would allow me to assert control over somebody else's property when I haven't actually acquired property rights in that property, and that's wrong. That would allow me to have power over other people. That would be inappropriate. It wouldn't reflect the equality, the legal equality of the parties. Okay, so the basic idea is that the reason that we have the rule that it doesn't matter who got there first is because that rule is required in order to prevent the defendant from gaining control over the plaintiff's land inappropriately, that is, without the plaintiff's consent. Or the consent of the person who owned the land before the plaintiff or whoever. Basically, the idea is if we didn't have this rule, you would allow people to gain control over other people's property by conducting acts of wrongdoing. And that can't be right. Now, if we could think about the cases that we've looked at in the light of this idea. So think about, for example, Sturgis and Bridgman. If we had the rule that who got there first mattered in Sturgis and Bridgman, then the plaintiff in Sturgis and Bridgman would have had to have moved his consulting room the moment that the defendant set up the mortar and pestle, right? In order to allow the plaintiff to continue to be able to control his own property, the plaintiff's own property, he would have had to have moved the consulting room immediately so that he could complain about the mortar and pestle immediately. As it were, the defendant would have been able to say to the plaintiff, move your consulting room immediately or lose the right to use your land, that part of your land, as a consulting room, that would allow the defendant to gain control over the plaintiff's land. In Kennaway and Thompson, to have the rule that, the defendant got there first, so the defendant wins, would allow the defendant to be able to force the plaintiff out of her property during the periods where racing is going on, to stay at her mother's. As it were, the defendant would be able to say to the plaintiff, well, look, when we're racing, go and stay with your mother's. In Miller and Jackson, what actually happened, because the rule who got there first doesn't matter was not applied, what actually happened was that the court allowed the defendant to force the plaintiff to leave home, or at least to sit out the front during cricket matches are being played. So the defendant was able to say to the plaintiff, look, when we're playing cricket, go out or sit in the front yard. Don't sit out of the back of your own property. That is to allow the defendant to control the use of the plaintiff's property. Now, in case you think, maybe you think that this is all a little bit over the top, you should notice that this is exactly what the judges who decided in favour of the plaintiff in this way said in Miller and Jackson. So here's a passage from Lord Denning's judgment in that case. He says, if he finds that he does not like it, he ought, when cricket is played, to sit in the other side of the house, or in the front garden, or go out, or take advantage of the offers the club have made from fitting unbreakable glass and so forth. Or if he does not like that, he ought to sell his house and move elsewhere. So in fact, Denning's quite clear that the defendant gains control of the plaintiff's property as a result of this decision. He's absolutely clear about this. In fact, he almost, as you see him in that passage, he's almost celebrating this fact. Right? When we're playing cricket, go out, sit in the front. As we'll see in a minute, you can't really sit in the front of the property, but okay, sit in the front of the property. Have bulletproof glass fitted. We'll do what we can tell you what to do with your own property. Now, if this isn't bad enough, what Lord Justice Cumming Bruce says in that case is, in my view, absolutely outrageous. So on the facts of this case, a court of equity must seek to strike a fair balance between the right of the plaintiffs to have quiet enjoyment of their house and garden without exposure to cricket balls occasionally falling like thunderbolts from the heavens, and the opportunity of the inhabitants of the village in which they live to continue to enjoy the manly sport which constitutes a summer recreation for adults and young persons, including, one would hope and expect, the plaintiff's son. Now, I submit, with all due respect to Lord Justice Cumming Bruce, this is an absolutely outrageous misuse of judicial authority in this case. What Cumming Bruce is doing in this passage is using his perception of the son of the plaintiff's interests against the plaintiffs themselves. He is setting his perception of their son's interests against their own interests. In fact, indeed, against their legal rights. And I think that is really totally inappropriate behaviour for a judge to do. It is deeply patronising towards the plaintiffs for them to be told by a judge what their son's interests are and how their son should be raised, and for that to be used as an argument against them in this case. So the idea, my idea that what happens in this case is that the court allows the defendant to control the plaintiff's life, that's hardly an exaggeration. I mean, what we see, in fact, is something much worse than that. Okay, now, but this, I submit, allowing this to happen is an act of injustice. If you want to gain control over somebody else's land, you have to get the consent of that person. Right, and you have to get some license or lease or whatever. You have to gain some entitlement from the person through their consent to do it. You can't gain entitlements to control someone else's property by committing acts of wrongfulness. And that's exactly what we see in Miller and Jackson. That's what we would see in other cases if the rule who got there first doesn't matter was forgotten. And so I think it's really deeply worrying that we are seeing the encouragement of the forgetting of this rule from the Supreme Court of the United Kingdom in cases like Coventry and Lawrence. the courts in these cases privilege the position of the defendant, right? They make the plaintiff, not completely, but in the way that is relevant to the case, they make the plaintiff subservient to the defendant. And I think that is a very significant injustice that the courts are perpetrating when they do this. There's also a suggestion in Miller and Jackson that Mrs. Miller ideally should not be able to sue because what she bought was land with an open space attached to it. So the idea is that Mrs. Miller, the Millers, bought land with an open space attached to it when the open space happened to be a cricket club. So now they can't really complain because what they bought was land with an open space attached to it, and the open space is being used for a cricket club. And what they're complaining about is just the consequences of the space being the open space that it was. Now, for exactly the same reasons, I submit that this argument cannot be right, because if we took it seriously, it would give the plaintiff control over the defendant's land. So according to this argument, the plaintiff bought their property with an open space attached to it. That's what they bought. They bought that. So now imagine that the cricket club decides that it wants to sell its land. Let's say it's found some preferable land elsewhere. That is better for the playing of cricket. There's more space, there's nice club rooms there. They'd actually like to move, and they want to sell this land and turn this land into, a housing development. Would the plaintiffs in Miller and Jackson be able to stop them doing so on the basis that they have a right that their house contains an open space next to it? The answer to that is no. That would allow the plaintiffs to control the defendant's use of the defendant's land. In this case, it's not actually likely to be owned by the cricket club, but we'll just pass over that for the sake of simplicity. The point is that when the plaintiff bought the plaintiff's land, that did not give the plaintiff any right to control the defendant's land. And you need to see that they're not trying to do that in this case. They're not actually saying don't play cricket there. They're saying don't hit cricket balls into our property and smash things. Right now, if you can't stop hitting cricket balls into our property without playing cricket, okay, you'll have to stop playing cricket. But they're not saying don't play cricket. All right? They're saying don't hit cricket balls into our property. They're not trying to control the defendant's use of the defendant's land. If the defendant can find a way of playing cricket without causing these problems, the defendant can continue. The defendant must not be able to gain control over the plaintiff's land, and nor should the plaintiff be allowed to gain control over the defendant's land. Saying that the plaintiff bought property with an open space attached to it, where that was somehow part of what the plaintiff bought, would allow the plaintiff to control the use of the defendant's land in ways that would be inappropriate, that would privilege the position of the plaintiff. No, if the defendant sells the land, or whoever owns that land sells the land and uses it to house people or builds whatever on it, the plaintiffs don't have an entitlement to complain about that. Okay. Another point that needs to be made in this context is that we need to realise that the defendants are not defenceless in these cases. There's a discussion of this in Sturgis and Bridgman, the discussion of the Blacksmith. So let me just quickly go through how that example goes. The defendant in Sturgis and Bridgman said, look, you can't impose liability according to the principles of the law that we've been examining, because just imagine this case. Imagine that you've got a blacksmith who sets up in the middle of nowhere, and the blacksmiths create noise, banging and so forth. But he sets up in the middle of nowhere. He's not annoying anyone. And then over time, all the land around him, people start slowly moving into it. They encroach on his property. They get closer and closer and closer to his property. And eventually someone gets close enough that they're disturbed by the noise. They sue for nuisance. Does the blacksmith really have to stop? That would be tremendously unfair, says the defendant in that case. And the court's response to this is to say, well, what's the problem here? If the blacksmith was there first, the blacksmith could have obtained enough surrounding land so that when people moved in, they wouldn't be close enough for a nuisance to be caused. If the defendant doesn't do that, right, if the defendant doesn't gain property in a sufficient amount of land, well, then that's the defendant's problem. Now, you might think, okay, I can see how that works in the blacksmith case. The blacksmith moves to an area, nobody owns the surrounding land. The he only acquires a certain amount of land and then people move in. Yeah, he should have acquired more land. Okay, to protect himself from a nuisance claim in the future. Okay, I get that. But what has that got to do with cases like Miller and Jackson? That wasn't possible for the defendants in Miller and Jackson to do that. But think about it this way. When the farmland was sold, the farmland that eventually became the plaintiff's land, the defendant could have bought that land. The defendant could have bought that land, but didn't. Right? In the end, the plaintiff bought the land. Right? The defendant could have bought enough land surrounding the cricket club to ensure that cricket could be played without damaging other people. They could have done that. It was possible for the defendants to do that, but they didn't. Now, you might respond to this by saying, well, look, they might not have been able to afford to. It's a cricket club. They're generally cricket clubs in the northeast of England anyway tend not to be rolling in money. Perhaps they couldn't do it. But here's the thing. Now, I take it that's a plausible view. Maybe they couldn't afford it. But how does the fact that they couldn't afford it justify imposing the consequences of their lack of ability to buy the land onto the plaintiff? Why does the plaintiff have to pay the consequences of the fact that the defendant couldn't afford to buy the surrounding land? And in particular, given the rule in Miller and Jackson, of course, even if the cricket club could afford to buy the surrounding land, they don't need to. Now, I also want to deal with this question about the public interest, because this is a very big theme in both Miller and Jackson and Coventry and Lawrence. So you might say, maybe I've convinced you that as a matter of justice as between the defendant and the plaintiff, justice as between the parties, as a matter of justice as between the parties, right, who got there first should not matter. But what about the public interest? Think about the cricket club in Miller and Jackson, for example. You know, they've been there for a long time. There's all these people in the village play cricket. What about their interests? Now, my answer to this is we actually have a system for dealing with that problem in the societies in which we live. That system is called democracy. Right? If the claim is that it's in the public interest that the defendant should be able to continue their activity in spite of the fact that on the face of it there is a nuisance, then the right way of dealing with that is to take that claim to what would in this case be the local council and make the claim in front of the councillors. Present the arguments. Now, one of the things that I find really disturbing about this case is that the courts present the issue as if the public interest was entirely on one side. That is, there's a public interest in playing, in Miller and Jackson, there's a public interest in playing cricket, and on the other side is nothing but the private interests of the plaintiff in the case. That is surely completely wrong. There is a conflict here between two public interests, one in playing cricket and another in housing people. And at the time, that public interest was very significant. There was a shortage of housing and something needed to be done, and that's why these houses were built. And we need to remember this because, as this goes through air, we're living in a time that's the same. Housing is a real problem. Right? We have a shortage of housing in most of the societies in which we live, in the jurisdictions that I'm discussing here. There is a shortage of housing, and it isn't to be assumed without argument that cricket is more important than housing people. There are complicated public interest arguments to be had here on both sides, and they need to be put in front of an appropriate body where those arguments can be aired and where an appropriate decision can be made. And that's patently not, and I submit, patently not the court. One thing to notice here is that nobody, apart from the parties, is actually represented in Miller and Jackson. There's a lot of talk by Cumming, Bruce and Denning about the interests of the villagers, but nobody's actually asked the villagers what they want. See, if there was a council hearing on this and the people from the village could go along to the council and have their say. No one from the village is having their say in this case. The public interest here, what's good for the village, is actually just determined by two of the judges in the case. The public interest is an important matter. It's not to be ignored, but it has to be discussed in an appropriate forum, and the appropriate forum is, I submit, patently not the court. Public interest arguments are complicated, they are multifaceted, there are many sides to the argument. It's not just plaintiff versus defendant. There'll be all sorts of different views out there, right? And they need to be heard in an appropriate public forum, and that appropriate public forum is some democratic forum, a council meeting or what have you. Now, I think in this case, in Miller and Jackson, there's plenty of evidence to suggest that in actual fact, the council would have been on the side of the plaintiffs, not on the side of the defendant. We can see that, for example, in Denning's claim that he was surprised that planning permission was awarded. Here you can see, was granted. You can see that here in this passage. Denning says, "I must say that I am surprised that the developers of the housing estate were allowed to build houses so close to the cricket ground. No doubt they wanted to make the most of their site and put up as many houses as they could for their own profit. The planning authorities ought not to have allowed it. The houses ought to have been so sited as not to interfere with the cricket, but the houses have been built and we have to reckon with the consequences." So what Denning is saying here is that a relevant public authority did actually look at this issue and decided that the houses could go there, but Denning doesn't like their decision. Now, okay, we may or may not like that decision as well. We may think that Denning's judgment is better than that of the planning authority in this case, but nevertheless, we can see here the potential, at least the potentiality for a court to be acting in a seriously anti-democratic fashion. I mean, as I suggest, we don't know this for a fact, but it may well be that if this had gone in front of the local council would have sided with the plaintiffs. And Denning's response to that is to say, well, all the more reason for me to step in and side for the defendants. In other words, what's happening here is that the court takes it upon itself to determine what the public interest requires. It doesn't allow public authorities, it doesn't allow democratically elected institutions from making this decision. And I think that is a usurpation of democratic authority. Another question that you might raise in this case is, well, aren't the plaintiffs really being unfair in these cases? I mean, the defendant got there first and was behaving in the way that they were, and aren't the plaintiffs being unfair? What do I think about that? Well, for a start, I just would say in Sturgis and Bridgman, the plaintiff is clearly not being unfair. What else was he supposed to have done? It's not clear to me what it would mean in that case to say that the defendant was being unfair. But what about in Miller and Jackson? Aren't the plaintiffs being unfair in this case? Now, it's clear that the judges, at least Cumming, Bruce and Denning, think that the plaintiff is being unfair. In fact, they think that Mrs. Miller is neurotic. But here again, I want to caution you against making personal judgments about the individuals in the cases. We just don't know enough about them. But I do want to show you this, unfortunately, not very good picture. Here's a photo, a satellite photo of the ground as it is, well, not today, but this is from Google Maps, when these photos were taken. And I just want you can't see it clearly, but you can see the damage that's been caused to the roofs of the houses in question. Now, I submit that when you look at this photo, it's not so easy to simply sit back and say, it's just a few balls coming over, what's their problem? There's actually a substantial amount of damage that's been caused to these properties. And you might also notice in this picture that there is no front of that. You know, when Denning says, they can just go and sit out the front of their house, well, what does that mean? Sit on the street, sit on the road, sit in their driveway. The back of their house is the only place where they can sit. And I think this amplifies the claim I made earlier that what we are really seeing here is the court allowing the defendant to control the plaintiff's use of the property. If you look at the roofs and you see the damage that's caused there, how happy would you be about being out in what would be your own backyard, right, while cricket was being played? I'd feel very uncomfortable about being there. I wouldn't let my kids play out there. I'd be worried that they were going to get killed, right? So I don't think we should be blasé about this. I don't think we should just say, what a neurotic old Mrs. Miller. You know, it seems to me, when you actually think about it, she's got a point. The other thing worth thinking about is when we think about this case. When we come to this case for the first time, we tend to imagine that Mrs. Miller knew nothing about and her husband knew nothing about the law of nuisance. It may well be that they actually thought about these issues before they bought the house. That is, for all we know, when they were looking at the house, they might have said, well, we really like the place, but it's right next to the cricket club and we're worried about, balls coming over and damaging our property. And they may have been reassured, don't worry about it. If that happens, you'll be able to prevent this. You'll be able to sue a nuisance. Right? And now when I say this sometimes to students in class, you can see that they laugh and they think it's totally, how ridiculous, it's totally implausible. But I want to know, why is it implausible? Why is it implausible? When they were engaging in conveyancing the property, no doubt they consulted, certainly at the time, you would have had to consult lawyers. Is it really so incredible to think that they may have asked lawyers what will happen if balls keep coming over into our property and damaging it? I don't think so at all. So it may well have been, for all we know, that the plaintiffs bought the house with the expectation that if there were problems, they would be able to do something about it. In just the same way that if you buy a house, you might be worried that you've got noisy neighbours, but you know that, well, if my neighbours are too noisy, I'll be able to do something about it. What's the difference? I don't think there is a difference. Now, the other thing that we need to remember about this, and I say this with particular reference to Lord Sumpson's judgment in Coventry and Lawrence, is that we really must remember that the parties can negotiate between themselves after the court has reached a decision. What the traditional law did is it said the courts are going to give a ruling that determines that where the outcome is determined by the parties' rights. But of course, it's then possible for the parties to negotiate between themselves to vary the outcome that the court reached. So an injunction could be awarded, but the parties can negotiate between themselves so to get some, for example, the defendant could buy the plaintiff's land, right? The defendant could offer the plaintiff some financial incentive to put up with the problem and so on, and they could agree to that themselves, and that's for them to determine. And that's what a law that focused on the rights of the parties permits. By allocating rights to the parties, it gives power to the parties and allows them to govern their own lives, in this case in part by negotiating between them. Sumption wants to take all that away from the parties, and he wants to be the person who gets to decide. And I think that is a profoundly mistaken view. It is an unjust view. It is an illiberal and indeed even authoritarian approach to lawmaking that I hope won't continue to have any influence on the Supreme Court of the United Kingdom. Although if you were asked me for a prediction, I would say that it is very likely that this is the direction in which the court is going. An increasingly authoritarian approach where power is taken away from the parties and given to the court, and the court, in its wisdom, which at least some judges think is pretty large, gets to determine how the parties should live their lives. But the main problem with this is not, well, there are two main problems. One is that it's just a violation of the party's freedom. It's anti-liberal. And the second problem is the court's not really in any position to make these judgments anyway, because it just doesn't know enough about the parties. If possible, surely the parties should be making these decisions because they're the ones who actually understand their own interests. The court barely scratches the surface of any of this. So for economic and for political reasons, to do with freedom and to do with efficient allocation of resources, it just seems to me it's much, much better to let the parties make their own decisions, for the court to determine the result of a case in accordance with the rights of the parties and then leave it to the parties to negotiate, rather than for the court to try and work out what's best. The court's simply not in a position to do that, and anyway, it's deeply authoritarian for the court to do it. Okay, so my argument is very much in favour of the Schaefer rule and of the traditional approach of the law of nuisance. I think these modern developments that we're seeing are deeply misguided. I think they're very worrying from a political perspective because I think, in short, I think they're authoritarian. And I also think they're worrying because it means that the parties won't be able to negotiate for what actually is best for them, because we'll have people who are really out of touch with their issues, who don't really understand what's actually going on in these people's lives, making decisions for them. And I think that that's highly regrettable. Okay, that's the end of the discussion of these cases. What we're going to do in the next part of this the next part of this long extended episode is we're going to look at two cases in fact, that take the sort of advantages model type reasoning to at least one of its logical conclusions. And I want to convince you that there's something really rather distressing about that. But that's for next time. So please, if you got something out of this video, please press like and hit like, and also subscribe so that you can be made aware of future videos. Thanks very much.